Day and welcome to the Equal Employment Opportunity chapter. I would like to highlight some of the important content and review with you this chapter. The chapter begins with the topic of fair pay. Let's look at a historical perspective. The first laws prohibiting discrimination in the workplace go all the way back to 1941. In 1961, the Equal Pay Act was established, which prohibited discrimination on the basis of gender for men and women doing equal jobs. And of course, we're all familiar with the Civil Rights Act of 1964 that protects all citizens from discrimination based on gender, among other reasons. Now, how are we doing today? Well, although the gender gap in pay has improved, women still make, on average, 88 cents for every dollar a man makes. So in a realistic term, a woman in the same position as a man would have to work all year and then until March 31st of the following year to make the same salary. Now, not every case where a man makes more than a woman in the same position is illegal. Those are called compensatory factors and could be defended in a court of law. Maybe the man has a higher level of education or more experience. Maybe he has credentials or he's a higher performer. These are all compensatory factors. Our text mentions the Equal Employment Opportunity. EEO prohibits discrimination in any term and condition of employment. The Equal Employment Opportunity Commission oversees the EEO. Another term mentioned in our text is affirmative action. Affirmative action is a proactive process whereby individuals are hired on the basis of their protected class. Well, you might ask, what are the protected classes? Well, those would be age, sex, race, color, religion, national origin, immigration status, and disability. Please review the types of discrimination found in our text. Especially read over the section about retaliation. Some types of discrimination include age, pregnancy, and disability. And believe it or not, these types of discrimination still occur in the workplace today. I want to highlight the Americans with Disabilities Act. That act requires employers to provide a reasonable accommodation for the employee to be able to successfully do their job. That includes employees and potential employees that are coming in for interviews, as long as that potential employee gives you information about their disability. After the employee provides medical documentation, an interactive meeting is scheduled. In that interactive process meeting, someone from HR, the employee, and their employer sit down to see if they can come up with a reasonable accommodation. The accommodation cannot cause an undue hardship on the employer. For example, if the employee cannot be around direct sunlight, the employee cannot ask the employer to build a basement office for them. That would not be reasonable. Some examples of reasonable accommodations. I had an employee who would get migraines, and I was able to find some covers for the lights so that the harshness was taken away and the employee was able to do their job. Another example, we had an employee who had arthritis, so we found some talk to type text to help that employee do their job. Sexual harassment quid pro quo is when a supervisor offers a promotion or a pay raise, etc., for a sexual favor. Hostile work environment is where the environment is so severe and pervasive with inappropriate language, jokes, ridicule, even physical threats. It's an environment where an employee would feel abused and intimidated. The only way to prevent sexual harassment is to provide mandatory sexual harassment training to all employees. Thank you and have a wonderful day.